26 states may be on the verge of losing their firearm permit requirements, not through legislation, not through elections, but through a fast-tracked Supreme Court decision that moved with almost unprecedented speed. And what's even more stunning? The Department of Justice, which for years defended permit systems, has now filed a brief supporting action that could dismantle them nationwide. If you want updates on this case as it unfolds, make sure you subscribe so you don't miss what could become one of the most consequential Second Amendment rulings in modern history. Let's break down what's actually happening, because the timeline alone is raising eyebrows across the legal world. When the emergency petition was filed challenging discretionary firearm permit systems in multiple states, most legal analysts expected months before the Supreme Court even considered whether to hear the case. Instead, the court acted within 72 hours. To put that into perspective, the average Supreme Court petition takes 6 to 9 months just to receive a decision on whether certiorari will be granted. The court receives more than 7,000 petitions per term. Fewer than 1% are granted full review. Emergency docket interventions are even rarer, typically reserved for imminent executions, constitutional crises, or nationwide injunction disputes. Yet, in this case, the court not only fast-tracked consideration, it requested expedited briefings specifically addressing whether requiring government-issued permits to exercise a constitutional right constitutes a form of prior restraint. That framing matters because prior restraint is a term traditionally associated with the First Amendment, the government blocking speech before it happens. By invoking that doctrine in the context of firearm permits, the court signaled it may be evaluating whether requiring permission before exercising a constitutional right is fundamentally incompatible with the Bill of Rights itself. Legal scholars immediately noticed the implications. If the court applies strict prior restraint analysis to the Second Amendment, the entire framework of discretionary permit systems could collapse. But the speed wasn't the only shock. It was what happened next. For decades, the Department of Justice defended the authority of states to implement permit regimes under public safety rationales. But in a brief filed shortly after the court's fast-track order, the DOJ took a dramatically different tone. Instead of defending broad discretion, the department argued that modern permit systems in certain states have evolved beyond historical precedent and now impose burdens that may conflict with constitutional guarantees. That language is unusually direct. Even more surprising, the DOJ did not merely argue for narrow reform. It suggested the court should consider whether conditioning the exercise of a fundamental right on government approval is constitutionally permissible at all, especially when delays, costs, and subjective evaluations are involved. That is not a minor shift. That is a potential doctrinal earthquake. Why would the DOJ reverse course so dramatically? The answer appears to lie in 3 developments. 1. Post-Bruin litigation chaos. 2. Expanding administrative requirements. And 3. Evidence of systemic disparities. Let's start with the first. In the landmark New York State Rifle and Pistol Association versus Bruin, the Supreme Court held that discretionary may-issue carry permit systems, which required applicants to demonstrate proper cause, violated the Second Amendment. The court established a new standard. Firearm regulations must be consistent with the nation's historical tradition of firearm regulation. In the wake of that decision, several states rewrote their permit systems, but critics argue those revisions replaced overt discretion with administrative barriers that functionally produced similar results. Instead of requiring good cause, some states expanded mandatory training hours, interview requirements, character reference mandates, extensive background investigations, broad sensitive place restrictions, and multi-month processing timelines. In certain jurisdictions, permit approvals dropped significantly, processing times extended from weeks to months, and in certain counties, beyond a year. Supporters called it enhanced public safety compliance, opponents called it regulatory resistance, and that tension is central to the Supreme Court's current fast-track review. At the heart of this case is a deceptively simple question. Can the government require prior approval before a citizen exercises a constitutional right? The First Amendment provides a useful comparison. The government cannot require a permit before publishing a newspaper. It cannot require approval before speaking in public. It cannot deny speech based on subjective character judgments.
Courts have historically treated prior restraints on speech with extreme skepticism. Now, the Supreme Court appears to be examining whether the same reasoning should apply to firearm carry permits. If the right to keep and bear arms is fundamental, as affirmed in Heller, McDonald, and Bruen, then requiring discretionary approval before exercising that right could be constitutionally suspect. That's not just a regulatory adjustment, that's a structural shift. And if the court rules broadly, the implications could extend beyond concealed carry permits. It could affect firearm purchase licensing requirements, mandatory waiting periods tied to permit approvals, training prerequisites that significantly delay access, subjective character evaluations. Which brings us to the numbers. Currently, 24 states operate under constitutional carry, meaning no permit is required for law-abiding adults to carry firearms. 26 states still require some form of permit for public carry. Approximately 82 million Americans live in permit-required jurisdictions. If the court invalidates discretionary or burdensome permit systems nationwide, those 82 million residents would transition to a constitutional carry framework. That would represent the largest single expansion of Second Amendment access in U.S. history. And that's precisely why this case is being described by some legal analysts as Bruin 2.0. But the court's fast-track order suggests something even urgent may be driving the timeline. Because in addition to constitutional doctrine, the justices specifically requested briefing on whether administrative delays and cumulative costs effectively operate as constructive denials. That language is significant. If the court determines that excessive processing times or financial burdens constitute functional suppression of a right, then states could be required to demonstrate compelling justification, not merely rational policy preference. And under strict scrutiny, many permit frameworks could struggle to survive. The next phase of this case will focus on the evidence, data, demographics, enforcement patterns, economic structures. Because beyond the constitutional theory, the court appears interested in whether real-world permit systems are operating as neutral safety measures or as gatekeeping mechanisms. And what the evidence shows may ultimately determine whether firearm permits remain a fixture of American law or become a relic of regulatory history. The constitutional argument may be what reached the Supreme Court, but the evidence that pushed this case onto the fast track appears to go much deeper, because when the Department of Justice reviewed post-Bruin permit systems across multiple states, the concern wasn't just legal theory, it was structural expansion. Permit systems today do not look like they did 20 years ago. What began as background checks and fingerprinting in many states has evolved into a complex administrative ecosystem involving private contractors, digital tracking platforms, multi-layered review panels, psychological evaluations, and extended processing timelines. And numbers reveal how large that ecosystem has become. Across permit-required states, firearm licensing is no longer simply a government service. It has developed into a significant economic network. Based on aggregated state contract databases, business filings, and publicly reported agency budgets, analysts estimate that permit-related services now represent a multi-billion-dollar annual industry nationwide. That includes mandatory training providers, live fire certification facilities, background check processors, fingerprinting contractors, digital application platforms, psychological assessment evaluators, permit appeal attorneys, and compliance consultants. In several large states, applicants must complete between 12 and 18 hours of state-approved instruction. Course fees range from $150 to over $500 depending on location. Fingerprinting services can add $50 to $120. Application fees often range from $75 to $300. In jurisdictions requiring character references, notarized documents, or interviews, additional indirect costs accumulate, including time off work, travel expenses, and legal consultation.
In some urban counties, total upfront costs for obtaining a permit now exceed $800 to $1,200. That does not include renewal fees. For critics of permit systems, the concern isn't just the expense, it's whether cost layering effectively conditions the exercise of a constitutional right on financial capacity. The Supreme Court has historically rejected poll taxes in the voting context. It has struck down excessive filing fees tied to access to courts. Now, legal analysts are watching to see whether similar reasoning could apply here, because if financial barriers disproportionately limit access to a fundamental right, courts often apply heightened scrutiny.
And that's where the demographic data enters the picture. The second issue drawing judicial attention involves time. In theory, permit systems are administrative checkpoints. In practice, critics argue that prolonged delays can operate as de facto denials. In some metropolitan jurisdictions, average processing times now exceed 120 days. In certain counties, backlogs have extended beyond 300 days. Appeal processes can add additional months. By comparison, in constitutional carry states, lawful residents may carry immediately without prior government approval. The Supreme Court's recent order specifically requested briefing on whether administrative delay and cumulative prerequisites effectively suppress the right to bear arms. That phrasing suggests the court is examining whether delay itself can be unconstitutional when attached to a fundamental right. There is precedent for this. In First Amendment cases, courts have struck down permit systems for public demonstrations when approval timelines were vague or prolonged. The reasoning is simple. A right delayed can become a right denied. If the justices apply that framework here, even shall-issue permit systems could face scrutiny if processing timelines are excessive. Another area under review involves approval patterns. Multiple academic analyses using public records requests have examined permit approval rates across income levels, geographic regions, and demographic categories. Some findings suggest approval rates in rural counties are often significantly higher than in urban jurisdictions within the same state. Applicants from higher income zip codes tend to experience faster processing and fewer denials. Administrative denials frequently stem from paperwork deficiencies rather than disqualifying criminal history. Supporters of permit systems argue that urban areas face higher public safety pressures, requiring stricter oversight. Opponents counter that constitutional rights should not fluctuate by zip code. If two applicants have identical backgrounds but different approval outcomes based on geography or administrative discretion, that inconsistency may raise equal protection concerns. The DOJ's brief referenced patterns of inconsistent application across jurisdictions, though it stopped short of alleging intentional discrimination. Still, the mention itself is notable, because once constitutional rights intersect with uneven enforcement patterns, courts often take a closer look. Beyond cost and delay, some states have expanded digital components of their permit systems. Modern applications may require detailed social media history disclosures, multi-year residential histories, employment background verification, and digital fingerprint retention in centralized databases. Supporters argue that modern threats require modern screening tools. Critics argue that the scope of information collection has grown far beyond historical analogs, which is particularly relevant under the Bruin historical tradition test. Remember, under Bruin, modern firearm regulations must be consistent with historical traditions of regulation. In the 18th and 19th centuries, firearm carry was often regulated through narrow prohibitions of misuse, not preemptive approval systems requiring expansive personal disclosures. If the court determines that modern permit systems resemble investigative vetting processes rather than historical carry regulations, it may view them as constitutionally suspect.
And that may explain why the DOJ shifted its position, because the department's brief appears to draw a distinction between objective, streamlined licensing and what it calls cumulative administrative frameworks untethered from historical analogs. That language suggests concern that some states may have layered requirements beyond what constitutional doctrine can sustain. Permit systems also create a complex reciprocity landscape. As of this year, dozens of states recognize certain out-of-state permits. Recognition agreements vary and frequently change. A permit valid in one state may be invalid across a state line. Law-abiding gun owners who travel across jurisdictions must navigate a patchwork of recognition rules, renewal timelines, and documentation requirements. Organizations employing armed security across multiple states often maintain compliance departments solely to track permit validity and reciprocity changes. Constitutional carry states largely eliminate that complexity within their borders. If the Supreme Court invalidates discretionary permit systems nationwide, it could dramatically simplify interstate carry rules, though states would still retain authority to regulate sensitive locations and prohibited persons.
Emergency Supreme Court review typically requires urgency. Legal analysts speculate that synchronized legislative updates in multiple states, scheduled to take effect within months, may have accelerated judicial action. If several jurisdictions were preparing to implement expanded permit requirements simultaneously, the court may have sought to resolve the constitutional question before those systems became operational. Because once new frameworks are fully deployed, reversing them becomes far more disruptive. The DOJ's support for expedited resolution may reflect concern about allowing potentially unconstitutional systems to entrench themselves. And that brings us to the final phase of this case, because beyond the economic impact, the administrative complexity, and the doctrinal debate, this case ultimately turns on a deeper principle. What does it mean for a right to be fundamental? If a right requires prior permission, substantial fees, months of waiting, and layered approvals, is it still functioning as a right? Or has it become a regulated privilege? That is the question the Supreme Court now appears ready to answer. And in the final section, we'll examine what a nationwide ruling could look like, how states may respond, the potential political fallout, and what this decision could mean for the future of constitutional rights far beyond the Second Amendment. If the Supreme Court rules broadly in this fast-tracked case, the impact won't be incremental. It will be immediate, and it could permanently alter how constitutional rights are regulated in the United States. Because this case is no longer just about concealed carry permits. It's about whether the government can require prior approval before a citizen exercises a fundamental right. And if the court answers that question decisively, the ripple effects could extend far beyond firearms policy. There are several possible outcomes. The court could rule that discretionary elements, such as subjective character evaluations, are unconstitutional, while preserving objective, streamlined licensing systems. Under this outcome, states could still require background checks. Training requirements could remain if narrowly tailored. Processing timelines would likely be capped. Excessive fees could be challenged under heightened scrutiny. This would resemble a tightening of standards rather than elimination. But based on the language in the emergency order, especially the focus on prior restraint, many analysts believe the court may be considering something broader. The court could hold that requiring government permission before exercising the right to bear arms is presumptively unconstitutional, unless the state can demonstrate a direct historical analog from the founding era. That would dramatically narrow modern permit authority. States might still regulate prohibited persons, felons, domestic violence convictions, etc., sensitive locations, criminal misuse. But blanket permit requirements for law-abiding adults could collapse. If that happens, the 26 permit-required states would effectively transition to constitutional carry overnight. That would mean no prior permit required to carry for eligible adults. Voluntary permits could remain for reciprocity. Administrative licensing departments would need restructuring.
It would represent the largest expansion of Second Amendment access in U.S. history. Not all states would accept such a ruling quietly. We've already seen in the wake of Heller, McDonald, and Bruen that some legislatures respond with new regulatory frameworks designed to test constitutional boundaries. If permits fall, states could pivot towards expanding sensitive place designations, increasing penalties for misuse, tightening prohibited person definitions, and creating enhanced penalties for unlicensed activity in restricted zones. The court is likely aware of this pattern, which raises another important possibility. The justices may craft their ruling in a way that limits regulatory workarounds. In recent decisions, the court has shown willingness to address not just the statute under review, but the broader enforcement landscape surrounding it. If the majority believes states are engaged in constitutional end runs, the opinion could include language warning against regulatory evasion. And that would elevate this case from a policy ruling to a constitutional boundary-setting moment. The political response will be immediate and intense. Supporters of permit elimination will argue law-abiding citizens should not need government approval to exercise a constitutional right. Data from constitutional carry states does not show dramatic crime increases. Administrative delays and fees function as barriers, not safety tools. Opponents will argue permits provide accountability, training improves safety outcomes, screening helps prevent irresponsible carry. Removing permits could complicate law enforcement efforts. The national debate will likely focus on public safety metrics. Expect comparisons between constitutional carry states, former permit-required states, urban versus rural outcomes, and crime trends before and after policy changes. But beyond the policy arguments, there is a deeper constitutional tension at play. Because this case could influence how courts view prior approval systems for other rights. Consider this. If the court rules that prior government approval cannot be required for the Second Amendment absent historical precedent, what does that imply for other constitutional rights? The logic of prior restraint doctrine is not limited to firearms. It applies to speech, assembly, petition, voting access. The court has long rejected systems where citizens must seek discretionary permission before engaging in protected activity. If that principle expands here, we could see a renewed judicial focus on how rights are administered across multiple domains. The Second Amendment may be the vehicle, but the structural doctrine could reach much further. And that may be why this case moved so quickly. Because once the court signals willingness to evaluate permit systems under prior restraint analysis, the constitutional framework shifts. If permits are invalidated nationwide, what changes for everyday Americans? In permit-required states, law-abiding adults who meet federal eligibility standards could carry without prior application. Permit offices would likely continue operating temporarily to manage renewals and reciprocity. Law enforcement agencies would update enforcement guidance. State legislatures would convene emergency sessions to revise statutory frameworks. In constitutional carry states, little would change internally. Voluntary permits for interstate recognition would remain available. There would likely be a transition period, but not an extended one. When the Supreme Court issues a definitive constitutional ruling, states must comply, and federal courts move quickly to enforce compliance when necessary. Previous Second Amendment cases clarified individual ownership rights. This case challenges administrative structure. Ownership was one battle. Carry outside the home was another. Now the court appears poised to examine the gatekeeping mechanism itself. That's why legal analysts are calling this the potential third phase of modern Second Amendment jurisprudence. If the first phase was recognition and the second phase was expansion, this phase could be normalization, treating the right to bear arms not as an exception requiring layered approval, but as a constitutional guarantee subject to narrow, clearly defined limitations. Briefing schedules are expedited. Oral arguments, if granted, would occur on a compressed timeline. A decision could arrive before the end of the term. That means states, advocacy groups, and legal observers are preparing now, because once the opinion is released, there will be no gradual rollout. There will be immediate legal consequences, and depending on how broadly the court writes its ruling, the permit era in half the country could end with a single sentence. So here's the fundamental question. Should a constitutional right require prior government approval, or should eligibility be defined narrowly, with enforcement focused on misuse rather than preemptive permission? The Supreme Court is about to weigh in, and the answer may reshape not just firearm law, but the architecture of constitutional rights in America. If you found this breakdown valuable, make sure you subscribe for continuing coverage as the case develops, because the next decision from the court may not just interpret the Second Amendment, it may redefine how rights function nationwide.